Welcome to Divorce and Beyond, a podcast about navigating divorce and what comes next. I'm Susan Guthrie. I'm a divorce attorney and mediator, and for more than 3 decades, I've helped people navigate divorce with clarity, strategy, and compassion. Each episode offers practical insight into the legal, emotional, and life decisions that shape your future. So let's get started. If you're in the early stages of divorce, especially right now during divorce season, there's something you need to hear before you sign anything. Because one of the biggest misconceptions people have about divorce is believing that once an agreement is signed, everything's done. But in reality, some of the most devastating divorce outcomes don't happen during negotiation. They happen later, when someone discovers that what they thought they were getting isn't actually enforceable. And when enforcement fails, the consequences are not just technical. They are financial, they are long-term, and they can permanently alter your future. So today, we are going deep into a topic that is rarely discussed, often misunderstood, and absolutely critical, especially where homes, retirement assets, or large financial settlements are involved. My guest is Kelly Lise Murray. She's a nationally recognized legal scholar and attorney whose work focuses on what happens when divorce settlements go sideways, particularly in cases involving real estate and high-value assets. Kelly has spent nearly 2 decades studying, teaching, and litigating the enforcement failures that leave people owed money, equity, or assets they never actually receive. She has trained thousands of judges, lawyers, mediators, and financial professionals across the country. And today she's here to explain, in plain language, why enforcement is not something you think about after the divorce, but something you must plan for before you ever sign an agreement. If you're negotiating a divorce, considering mediation, or assuming that a signed agreement automatically protects you, this is an episode you do not want to miss. Let's get into it. Welcome, Kelly. I'm so delighted that you're here with us today to get into the nitty-gritty of a really nuanced and misunderstood topic. My listeners are very lucky to have an expert of your caliber to help them understand and receive some insights so they know what to do as they move through the divorce process, and most importantly, before they put pen to paper and sign that divorce agreement. So thank you very much for joining us.
Thank you, Susan.
So this is one of those things, and I've seen this in my 35 years of practice, right? They finally, after months, if not years of negotiating, they finally get to the point where they write that up with that agreement. Everyone sits down, or these days, DocuSigns agreement, and they think, aha, done, move forward, it's all over. And yet, your area of expertise is letting people know that might not necessarily be true, right?
Well, I'm so delighted to be able to talk about the nitty-gritty because it's equally important to all the other topics you've been covering. If you can't enforce the settlement you just agreed to, you technically end up without what you agreed to. And so enforcement is such an important and really not talked enough about aspect of preparing for a settlement. I really believe the best enforcement strategy is to think it through before you even go to mediation. There are things you can do and add to the settlement, for example, that could help you enforce later. There are things that you can leave out that can hurt you later. And so we're going to be covering it in a way that's understandable, but this is going to raise questions that folks can ask their lawyers about, or if they're interviewing a lawyer, it would be excellent to say, what are your thoughts on enforcement? What can we do before mediation to ensure enforcement? How does it work in our state? Those are substantive questions that for the lawyer you're interviewing, you can get a feel for how you interact with them and really how comfortable you feel with their approach.
I think it's something people don't automatically think of. They think it's written down, I signed it. He or she signed it. We're done. Of course, it's enforceable. We went in front of a judge, or the paperwork did. And of course, it's all pulled together. But enforcement, right, is something, I think maybe it's not the sexy topic that everybody,
But it should be.
it should be, because if you're not getting paid, if you're not getting the money or what you bargained for, it's not always money. It could be something with your children. It could be something with different things. But if you're not getting what you thought you were getting, or you're not receiving something that you bargained for, it has a material effect. And I mean it very seriously, a material effect on your life. You may have planned on that money. You may have planned on that outcome, and now it may not happen.
One other aspect is alimony. So I'm approaching enforcement from a property perspective, and this is what my legal scholarship is focused on for over 15 years. Real estate assets and everything related to real estate, for example, the mortgage, secured debt, and other liens, and then also retirement assets. But this applies to alimony. I'm seeing a lot more in litigated cases. That's what I focus on. How did it litigate? But I'm seeing folks waiving spousal support, mutually waiving spousal support. What if everything you agreed to in terms of property you don't receive, and you've previously waived spousal support? There's a strategy there to keep in mind that any waiver of spousal support could be contingent on you receiving everything you're supposed to get. And if for any reason you don't receive it, that may be a way to go back, depending on the legal reason you're unable to divorce, and depending on the reason you're unable to enforce your property division, keeping support contingent on receiving everything could help you make lemonade, for example, at that point.
Love that way of putting it. And we're starting off with a bang, because this is a big one. Honestly, I cannot count how many times that we have seen mutual waivers of alimony, especially if you have two spouses who were earning, or there's so many assets in the marriage that presumably both are receiving enough that spousal support is not called for, alimony is not called for. It's almost a offhand, oh, well, everyone's just going to waive alimony, right?
Super common. It is super common.
Really common. And what most people don't realize, or maybe isn't focused on, is once it's waived forever.
And if you cannot, for any reason, there are lots of reasons folks can't enforce what they had agreed to receive, you can't go back and get alimony if you waived it. So this is your pre-mediation prep with your lawyer, and it's a reason to have a lawyer at your mediation, because there are so many nuances to things. And really what I'm seeing in the litigated cases, trial court, since being affirmed on appeal, if there's substantial assets to be divided, the mutual waiver of support, mutual waiver of maintenance or alimony, whatever your state calls it, is rubber stamped. Or if you go to trial and try and get support, you may not get it if you're getting substantial assets. Meaning, if you have agreed to receive substantial assets, enforcement determines whether you actually get them.
Well, and I think you bring up a really important point that most listeners are not going to understand the nuance. And that is, most divorces go forward with a written agreement, with a negotiated and written settlement agreement, marital settlement agreement, separation agreement. Called all different kinds of things, but it's essentially your divorce agreement, and it contains what you've agreed to. You just mentioned cases that have gone to judgment, cases that have been litigated. And when you litigate a case, you get a very different, I'll call it, written product at the end, right? That outlines what you get. Instead of it being an agreement, it's now what the judge has decided that you get. And maybe you could explain that a little bit more for the listeners so they understand the nuance there.
This is another topic to discuss with your lawyer. Whether you have a mediated agreement, property settlement agreement, marital settlement agreement, separation agreement, or a judgment where you went to trial on these property issues and the judge is the fact finder, he concludes based on the facts in the record and the law that you get X and your husband gets Y. Regardless, you have to look at in your jurisdiction, the phrase is incorporated and merged, or incorporated but not merged. So if you have a judgment from the judge, it is a court order. And that's where contempt and other enforcement mechanisms come into play. But if you have a contracted agreement, so if you go to mediation and agree with your spouse and the mediator writes it all down and you both sign it, that's right now it's a contract. You have to find out from your lawyer whether your jurisdiction gives you a choice. Some don't give you a choice. Sometimes when the judge has to approve the property settlement agreement, it gets incorporated and merged into the divorce judgment. If your contract, your property settlement agreement is incorporated and merged, it is no longer a contract. You can't enforce it as a contract. It's interpreted by any court if you later have a dispute about it. They use contract principles, but it becomes a court order when it's merged. The same result happens if the trial judge, you went to trial on these property issues or spousal support issues. If you go to trial on those issues, then it's not mediated and it's not a contract. It is a court order. And contempt is available for that, except in some states. There's craziness going on, but that's the court order side. If you go to mediation like many people do, and your mediator writes your agreement down and you sign it, and you and your lawyer choose, because it's available in your state, to incorporate it but not merge into the divorce decree, you have a contract that is not it's enforceable, but it's only enforceable as a contract. There is no contempt. So most people think of enforcement as, my spouse is in contempt. No, they could be in breach of your settlement agreement, but if it was incorporated but not merged into your divorce judgment, it remains a contract and can be only enforced as a contract. And so those contempt procedures are not available. You would enforce it as a contract. And so that's something to find out early on from your lawyer. Is this incorporated and merged, meaning my contract now becomes a court order? Or do I have a choice? Can I agree to make it incorporated and not merged? And why would you want to do that? Because sometimes at mediation, you and your spouse want to agree to things a trial judge can't give you. And that could be paying child support through college. That could be unique handling of retirement assets, something that the court can't do based on your state statutes. But as long as it's not illegal and not against public health, you can contract for things at mediation that the court can't give you. So that would be a reason to not go to trial. That would be a reason to settle at mediation, because you can enforce that mediated agreement as a contract. So those are some of the things, but you basically want to find out from your lawyer before mediation, what's our strategy for enforcement? Does our state give me a choice? Can I keep my settlement agreement a contract and enforce it as a contract and not as a court order? Or is it just everybody in our state, it's incorporated and merged, and that means it is construed or interpreted by the court as a contract, but it's enforced as a court order? Because if it's a court order and your state has a statute not allowing something that is not, whatever term that goes against what the court has the authority to do would be itself unenforceable.
Right. And that's the kicker right there. When you find out that something in there is not enforceable, but you thought it was, that's the kicker.
And there is a mechanism if it was a mutual mistake. So there's a procedural rule. And this is why you want to have that conversation with your lawyer about how are we going to enforce? You're going to have your mediation plan. This is what we're going to ask for. This is what we think the other side's asking for. How do I enforce my portion, what I am bargaining to receive? If it's a mutual mistake, so for example, if a retirement plan the plan administrator will not accept a quadro, a qualified domestic relations order, and you and your spouse negotiated that you would get half of his employer-based retirement plan through a quadro order, and after divorce, the administrator of the plan rejects it, well, how do you get access to those funds? You're not the plan participant. So what you want to do is find that out early on or write in contingency so that if what we've agreed to fails, I still get the amount we agreed on. We're just going to use a different mechanism. So for example, there was a case where the retirement plan was the husband's employer. The wife is getting 50%. She's supposed to get it through a quadro order, qualified domestic relations order. After divorce, the plan administrator says, nope, we don't accept quadros.
We're not doing that.
So in her motion to enforce, the trial court agreed it was a mutual mistake. Both spouses thought the plan would accept a quadro. Since the plan didn't accept a quadro and was paying all the retirement directly to him, the court was able to modify, was able to clarify, was able to resolve the mutual mistake and change how the wife would receive the retirement assets, not through a quadro, but the husband actually paying her because the plan's paying him. But I just want to point out, with everything we talk about, there's always a state with an exception. And I saw a litigated case with the opposite result in a different state. It's kind of scary. So I just described that it sounds like a mutual mistake. We both thought quadro would be accepted by his employer's retirement plan. Different state, it's supposed to be a quadro. Wife is getting 100% of his retirement plan, and he got more of something else. The administrator after divorce rejects the quadro, and when the wife moved to enforce, that trial court in a different state held that because there were no contingencies, the husband just gets to keep the money. That
And
they had
she gets
agreed.
nothing.
She gets zero.
Right.
So especially that's why I wanted to focus on house issues and retirement issues. You want to find out as much as you can before mediation, and then the milestones of your divorce, because there are deadlines to enforce. There are deadlines to file a motion for mutual mistake, for example. And finding it out sooner is going to help you and your lawyer plan for contingencies. If this, then that. If this doesn't work, then how else do I get paid? And it should be the first version. It should be a mutual mistake, but sometimes it's not. And you risk getting zero of something you bargained for and gave up to balance things out. And I would hate for anyone to have that happen if we can prevent it. So this is mostly about prevention.
Well, I think that's the very significant takeaway from what you're saying here, is because there are no certainties other than you already received it. Right? Like, that's the gold standard, folks. If you're supposed to get something in the divorce, get it at the time of the divorce,
Absolutely.
and then you've got it, right?
As much as
that's the
possible.
gold standard. But it is not always possible. We know that just for practicalities and reasons. But what I hear you saying, and what I want a listener to take away here is very important, is when you are negotiating, you want to be negotiating not just what you're getting, but how you are sure that you're going to get it, right?
Absolutely.
Like, and what happens if you can't get it or it doesn't work out the way? So the negotiation goes further than I get 50% of the pension, or I get 50% of this, that, or the other thing, or whatever the negotiation is. The negotiation and the discussion with your lawyer, which is so important that you raise, is that then how do we make sure it actually happens? And what happens if it doesn't happen?
Right. And so the technique is contingencies, where if this, great. If not, now what? And planning that out with your lawyer and getting it into the settlement agreement. And one caveat on that, there was a divorce in Florida where the husband was keeping the house. He was required to refinance the marital mortgage, and he was required to pay the mortgage on time before refinancing, and hold the wife harmless from his failure to pay the mortgage on time. And the contingencies were linked. You want to be careful about having these contingencies. You must have both. So the contingencies were this: if he failed to refinance and if he was late on the mortgage, then she could force the sale of the house because he was going to use the refinance to pay her share of the house equity. Right. Well, he did not refinance, but he was never late on the mortgage. So guess what? She can't force the sale of the house, and she is still obligated on the mortgage. So if he ever in the future is late, that's going to damage her credit. That's why she and her lawyers bargained for her to be removed from the mortgage. It's very common to get that into a settlement agreement. But the disappointing result when she tried to enforce his failure to refinance was that the two were linked. So what you want to consider is one or two. If he's late on the mortgage, and you want that at a short period of time, or if by a certain date, so deadlines are really important. If by a certain date he does not refinance successfully, for whatever reason, he could make a good faith effort and he just doesn't qualify, or he could blow it off and not even try. But if by a certain date he does not refinance, that should have been a contingency to allow her to force the sale of the house, because hers were linked, that he needed to be late on the mortgage and not. She couldn't force the sale of the house and just get her money and be done with him.
Well, and think about the very small difference that we're really talking about here. It was the use of the word and versus or.
Absolutely.
Right? It's like that where the comma goes. There's that whole case about the comma. But I think that's so what I'm hearing you saying, the contingencies are truly important, right? Having the contingency, like this has to happen, but also making those contingencies so that you retain the control that you're essentially bargaining for with those contingencies, right? You're protecting yourself, you're protecting what you're supposed to receive, and don't end up with this unintended consequence because of one misplaced or missed word.
Right. And similarly, if you have zero contingencies, I've been following this next issue for years. So I'm a research nerd. My legal scholarship has been based on wealth dispute resolution, mostly family matters. There's a hold harmless provision that gets put into almost every mediated settlement agreement. It should be there. So if one spouse keeps the house and that's house spouse is supposed to refinance, the non-remaining spouse should be protected from the house spouse's failure to refinance and failure to pay the mortgage on time, because until it's refinanced, both of your credit scores are at issue if you're co-borrowers. That hold harmless provision, folks have tried to enforce the hold harmless by saying, well, he didn't refinance, he's not paying the mortgage on time, my credit is tanking. Post-divorce trial judge, I should be able to force the sale of this house just under the hold harmless provision. What the answer is? No.
Yeah.
Hold harmless is important. It should be in your agreement, but it does not give you on its own the power to force the sale of the house or the power to force a refinance if you didn't write that into your settlement agreement. So that's why those terms are really important. Those contingencies are really important, because the trial, and the reason why that gets rejected by almost every court that had been presented to is because that would be a modification of what is now permanent property division. Unlike support, it's difficult to modify support. You have to have a showing of a substantial increase or decrease in either need or ability to pay. But property division is the part of the divorce that's supposed to be final. Otherwise, divorces would never end. So property division is generally permanent. And unless you have contingencies, what you're asking for, we didn't write contingencies, but he's not paying the mortgage on time. Now I want the house sold, or title the house back to me. All of that is an improper modification, and it gets reversed on appeal.
Yes.
But if you had the contingency, if you had it written in, if this, great. If not, if something else is happening, now I can force the sale of the house. Now he has a deadline to refinance, and if he doesn't refinance, I can force the sale and get my share of equity now rather than just waiting till the 12th of never.
Well, and it's something that's important, I think, to point out here is this isn't really a trust issue. It may have a nuance of trust, but all the instances that you're talking about have really been things that I'm sure at the time the people, and I've negotiated a million of these settlements, where they're like, for sure, I'm going to be able to refinance. My mom's going to co-sign for me. All these things that are supposed to happen for sure are going to happen. And then COVID happens, or mom passes away and doesn't co-sign, or whatever. You just don't know without a crystal ball. And this is the true danger of entering into these agreements when you have property settlements that haven't been effectuated at the time of the divorce. And as I said earlier, there are reasons why sometimes you can't do that, right? The house, my favorite one is always, because it happens in almost every divorce, is someone's going to stay in the house for a certain period of time until the kids graduate from high school, and then we'll deal with it. And everybody always thinks this is going to sail along so smoothly. It's all going to work out. And then a tree falls on the house, or something goes wrong and happens. So what you're really, I hear you saying, is with these contingencies, with thinking through carefully, not even all the things that might happen. You don't need the crystal ball to know about the tree. You need to have the contingencies for if what you think is going to happen doesn't happen, you have some recourse to do something else.
It's the worst case scenarios you need with your pre-mediation plan. I am asking for this. I expect him to ask for that. What if any of the items, the big items on your list, you don't receive? What will happen to you? That can be negotiated. That's why it's so important before mediation. It's important to have a lawyer working with you and to bring that lawyer to your mediation so that you can work into your mediated agreement these protections, because these are simply enforcing the agreement as agreed, as written and signed by husband and wife, versus So for example, if there are no deadlines, so there are examples where a spouse who keeps the house is supposed to refinance, good faith effort to refinance. And
I've
then
seen this clause. I've seen
and
this
then the
clause.
other spouse is going to be paid their home equity share out of the refinance. Well, there's a case where the non-remaining spouse lost because there was no deadline. 2 reasons. There was no deadline.
Yeah.
So the remaining spouse, if there's no deadline, even if it's a court order or merely contract enforcement, there's no breach if there's no deadline. They have 12th of never till they have whenever they feel like it.
Or
So
never.
you want a deadline. But the other thing that went wrong in this case was the spouse retaining the house was given full title without the contingency of the refinance being funded. So even though the agreement as a whole had the non-remaining spouse getting a certain amount of money in equity, the court, the appellate court, as it litigated on appeal, concluded that, well, the remaining spouse already has title. She tried to refinance. It didn't work. Oopsie, he doesn't get paid his house equity. He gets 0 house equity because of how this was structured without a deadline and without contingencies.
And without contingencies, right?
Both
The
of those.
magic words. Yeah. So the magic 2 words, everybody. You want your contingencies and you want your deadlines. I have seen, I can't tell you how many times in post-dissolution work where people have come in with that clause where the spouse staying in the house shall refinance or use all due diligence, blah, 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 blah. But there's no deadline. And I have over and over seen that happen.
Now, I train real estate agents and mortgage professionals to help with these house and mortgage issues. And so I've been doing that since 2008. And what all of these examples I'm giving you, I teach them so they can help you and your lawyer identify these danger zones regarding the house, regarding refinance, regarding not selling it, because keeping the house is one of the most dangerous decisions. It seems expedient. And like you mentioned, Susan, it's an easy decision at the table, but it may not be easy, smooth sailing after the divorce. And so these are just some of the reasons that makes that dangerous. And really, if one spouse is keeping the house, you need 2 lawyers coming up with the contingencies. You should not be DIY divorcing this way because too many things can go wrong and prevent enforcement. And are you comfortable not getting your share of house equity? Because that's happening to people.
Right. Well, think about that. Think as you're sitting here, everyone, as you are going to sign your agreement that says what you're going to receive in your divorce, and how will you feel on the other side if you don't get one of those things?
And I think that's enough of a wake-up call for anyone to look at their priority list. And you mean I don't get this? Even one of those things, but the big one, the house equity, given how the market has performed, is a big ticket item. Everyone deserves their share, and so we need to make sure the agreement is structured so that you can enforce it and and so that the court is merely enforcing what you agree to. And I have another suggestion, an intent statement. Sometimes the mistake is we're intending to divide things 50-50, and then it doesn't get written up as 50-50. And you try and enforce it, and it's unclear. It would be probably helpful, given how the appellate court decisions are written, to have an intention statement. We intend to divide the retirement assets this way. We are proposing a quadro order, but if it doesn't work, the retirement assets still have to be divided. If it's 50-50 or 60-40, or sometimes it's 100%. So those intention statements could also go a long way too, because then the court could enforce your intention and then clarify by what you agreed. The mechanisms agreed to didn't work, but the intention is clear.
I have to tell you, you're making me feel better, because when I was practicing, I was a big fan of intention statements. The parties, it is in the intent of the parties to we are doing this to effectuate that, blah, 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 blah. Right. So I would receive arguments sometimes from opposing counsel about putting intention statements in there. It's like putting in the language that neither party shall denigrate the other and shall do nothing. And they're like, that's aspirational language. And I'm like, no, it's very different from aspirational language. When you're putting in what the intent of the parties is into an agreement, you're letting the court know what you were trying to effectuate in case there is a problem down the road. Because the reality for divorce agreements And this episode is making this very clear. But the reality for divorce agreements is it's a rare agreement or a rare divorce that happens where everything is done the day you get divorced or the day you sign your agreement. It is very rare, right? Like people think I practiced in California where it's 50-50 community property, everything's split 50-50 that's community. And everyone thinks that's so simple. But the only way that's simple is if you liquidate every single thing that you own and hand each person a check for 50%. That is really, or you start cutting things down the middle, literally, because that's the only way to do it. So it's really a rare divorce that wouldn't have clauses in it that need this level of scrutiny and care that you're talking about. The other thing that I want to point out to listeners, it's funny, I just put a post out today on my Instagram because someone had written in about, hey, my spouse and I were going to mediation. We really generally agree on everything. We're very amicable. Do we really need attorneys? If you're listening to this episode, I need to go watch the video that I just put out where I said, yes, you still need attorneys. I think you're hearing here just how important a role your attorney, who is the one who generally helps craft this agreement and make sure that it has these provisions that you're talking about, has the deadlines and everything that you need so that your enforceability is there. But you too, as the client, need to be concerned about this.
Right, absolutely, because I've seen litigated cases where the court points out that one spouse, if, for example, in the issue of discovery, when people can choose to remain uninformed, that's binding. If you choose not to push the other side to give you what you've asked for, you just rely on their documents and don't present any financial investigation of your own, that will be held against you if enforcement litigation happens.
Yep.
So you want to read your plan, your pre-mediation plan thoroughly so that you understand deadlines. Is this the 12th of never? Is XYZ, is this ever going to happen? You want to ask about contingencies so that you're prepared with your lawyer before mediation. But I do have a suggestion for the amicable folks, because that's not uncommon.
Right?
So the big ticket assets are the house and the retirement.
Yep.
For house issues, if you really are feeling that you don't need a divorce lawyer, I recommend you hiring a real estate lawyer for 1 to 3 hours with your mediation plan and your plans for the house and the mortgage and any other secured debt against the house. Because a real estate lawyer charges by the hour. They mastered limited scope representation, so they're not going to go with you to your mediation, but they can certainly give you advice, because the house is a legal and financial quagmire of an issue.
Great.
What the house means to you psychologically, financially, physically, all those things. But it also, with the way the market has appreciated, folks went from modest equity to significant equity. And hopefully your debt, especially if you have one of those low interest rate mortgages, you may be thinking, oh, one of us should keep it. A real estate, if you're not, I recommend a divorce lawyer. But one fallback position on your house issues, you can work with the folks that I've trained. Our designation is called RCSD. They can help you with some of these challenges and contingencies in the real estate and the mortgage issues to help you with your plan if you don't have a divorce lawyer. And then going to a real estate lawyer with that information, now you get the legal advice about the house issues. That would be a not bad backup to we don't need lawyers.
It's I always called those the CYA measures. You want to make sure. And let me point out, it's not just real estate attorneys. When I was practicing, I practiced in an area with a lot of hedge funds. And so we often had really complicated retirement packages to deal with. And I understood them fairly well. I practiced in the area for a long time, still brought in an expert to draft that part of the agreement. And if we were mediating, I would bring her in to help co-mediate the quadro portions, the pension portions, the retirement portions, because that's, as you point out, the home is usually the biggest asset and the biggest debt. Next by far, and in some cases much larger, can be that retirement. And I will tell you, I know you've seen them, but I've seen as well the horror stories that happen, especially when it comes to those quadros. So many things that can go wrong there, but all different kinds of problems. Not every retirement account allows for division, allows for sharing, allows for success, or if one of the parties passes away, for the other to be the successor. They all have to be looked at very carefully.
There's a couple more things I want to point out. One
Yep.
is the statute of limitations.
Ooh.
This is something that really isn't talked about very much in the literature, and it's really important. And I'm seeing it in litigated cases on appeal where 20 years after a divorce judgment was entered, someone's trying to exercise their rights against retirement assets. Well, 20 years is probably too late. So the one thing you need to talk with your divorce lawyer about before mediation is how many years do I have to enforce this divorce judgment? So there is a statute of limitations. It may be shorter or longer for family orders or for contracts. If your settlement agreement is not merged into your court order, it would be enforced as a contract, but there still may be a family law procedural rule setting a different statute of limitations for a written marital agreement. You want to know the statute of limitations because within your original time period, so let's say it's 10 years, you have to renew it in order to get a second set of 10 years. You could time out on your ability to enforce your judgment. And that is a question to have, a conversation to have early on with your lawyer. And you really need a diary of what are the deadlines? What am I supposed to do? And when am I supposed to do it? And what's the other side supposed to do? And then these overarching deadlines of the statute of limitations. When does my judgment, my divorce decree expire, meaning I can't enforce it anymore?
Right. Which is a significant date because for all of you out there who are thinking it will have all been completed by 10 years, not always. There's a variety of, imagine where you have the marital residence and one of the spouses will stay in until the youngest child attains the age of 18 and that child is 6.
Exactly.
I've had that agreement more times than I can count. So I think it's really significant. You've also talked about the differences between states. And I want to hone in on that just even a little bit more. I talked about California and how I had the interesting perspective of practicing most of my career in a community property state in Connecticut. Then I moved to California and I naively thought, oh, community property is going to be so easy. It's just everything split down the middle.
California has so many statutes.
I know.
In family matters, they're hers, and then any kind of procedure. So California is its own thing, and it's a lot.
Say I had to take the bar there after having practiced for 26 years. Yeah, they've overcomplicated the situation. But there are other states that have really vastly different laws. So when you're talking with an attorney about your enforceability, the other important part is it needs to be with an attorney who is very familiar with the laws in the state in which your agreement's going to be enforced. And that may be something to touch on because it's not always the state that you're in.
Right. So, for example, if you or your spouse move, so let's say your spouse owes you equalizing payment, house equity, or any other asset, and then leaves the state where you resided while you were married and he's in a different state, you have to record your judgment in the state where he lives as a foreign judgment in order to enforce it against him in his new state.
Yeah. I mean, it's extremely complicated and people's lives don't stay static. You think he grew up here, he's going to be here for the rest of his life. No, people move, change. And again, unless everything is done in the agreement, you are going to have these issues in your divorce decree.
Well, one more thing to think about, and again, your pre-mediation plan with your divorce lawyer is some sort of security for payments that are going to be paid to you over time.
Oh,
because
like this.
Over time, things happen. There was a 2024 appellate decision in Ohio, high asset divorce. The equalizing payment to the wife was almost $29 million over 7 years. And she and her lawyers argued to the trial judge for security. And I typed it all down because there were so many things. She was asking for a promissory note, security agreement, liens, guarantees, stock transfer restrictions. And the trial court wrote, oh, this very, very wealthy husband, he'll pay. He has no reason not to pay. And the court.
Well, there's a trusting judge.
Almost 29 million. So on appeal, it gets vacated because it's a terrible decision.
Yeah.
But the other nuance of asking for security, so a lien on the marital house, any other way, but something to think about is, and ask your lawyer this, will it be enforceable against my former spouse's estate?
Oh,
not just against my former spouse. So even if you didn't need the lien against your spouse, you may need it to enforce against the estate, because he could have, after the separation, he can change his estate planning, and he may have he may have irrevocable trusts and a pour over will and everything to box you out. And without that security from the divorce itself, you may not be able to recover, even if you're still he hasn't finished paying and he dies for whatever reason at whatever age. If you're not paid and you don't have the ability to collect against the estate, or it will be difficult, that would be another way for an enforcement fail. So I don't want that. We don't want
enforcement fail. You don't want enforcement fails. That's just the bottom line of all of this, folks. You do not want enforcement fails. And unfortunately, these are the sorts of things that keep divorce attorneys up at night worrying about things, because these are the difference between the word and or in an agreement. I mean, these are the things that seem so simple, I think, to everyone at the time. And the other thing that happens, and this is just purely from the human perspective, but people who are negotiating and going through divorce and going through the upheaval, again, I said earlier, it takes months, more often years, to get through this process. They just want to sign and be done. They just want it to be
That's
done.
the danger moment.
Yes.
You want to break. You've run the gauntlet. You've finally made it. It's signed. That's when you need to be more vigilant. I have a number of litigated cases where the shenanigans happened right in that time period when one spouse wasn't looking.
I love your legal terms, the shenanigans.
The shenanigans. Well, I teach continuing legal education, and I teach these topics to lawyers, hopefully your lawyer, because I'm so passionate about, if we know about it, we can do something about it. And if your lawyers know about it, and divorce lawyers know a lot about a lot, but it's difficult to spend the time to anticipate all of this. And so that's why it's so important to make sure you and your lawyers have access to the information so you can raise the conversation early while you have all your options open, because in mediation, you could agree to things about the retirement. So, for example, the retirement could fund your support if you are not paid on other things, but only if it was negotiated at the mediation table. That's not something a court can give you after the divorce is over.
Right. And I have to say, so I mediated for a long time and would do the mediations that start first thing in the morning, and it's 11 o'clock at night and we're still locked in the rooms and doing that. And I was always against the idea. I love to get to the point where we had an agreement. I was always against the let's draft this up and sign it before anyone leaves the room. And because, as you said, that's where the shenanigans happen.
Absolutely. And that's really the common, you need to be careful in how you pick your mediator, because that's common for many mediators, and that may not be to your advantage. I'm exhausted. We've exhausted everybody, and now they're just agreeing to things because we won't let them out of the room.
No one eats, no one goes to the bathroom, sign that piece of paper. But I've seen that. I've also been an attorney in those rooms with my client. And there's a lot of danger there. I don't think that is really the goal of mediation, is to exhaust people to the point where they, out of fatigue, agree to something. And the humans in the room, who also happen to be attorneys, might draft something that hasn't had the ability to be fine-tuned to the degree that you're pointing out is really actually very necessary.
Susan, on this point is, you need to read the draft mediation agreement to make sure, from your perspective as the client, this is what you agree to, because you and your lawyers have more options right away than you do later. Finding something was left out, something was miswritten, accounts were transposed, or numbers were wrong, because the math mistakes could be binding too.
Yeah, those have definitely... Math was never my topic. That's why I became a lawyer. There are so many issues that can come up for people at a high level, I do want people to be aware it's when you have something in your agreement that isn't accomplished yet, right? Like you
Yes.
haven't gotten something that you bargained for. That is where you need to have this very heightened level of scrutiny and to build in the deadlines and contingencies.
Right. We want you to build in the deadlines, no 12th of never. It's actually going to happen, or a consequence. That's where the contingencies come in. And you as the client, you can read this and ask yourself, when am I getting this? And if he doesn't do it, then what happens? Those are questions you can read it yourself and then ask your lawyer, because again, early intervention is the best option.
Yeah. This is one of those areas, as you've heard in this conversation, where unfortunately the soft spots, the shenanigans come out because mistakes have been made. And
Right.
that's where lawyers have learned about these things and where to be careful and learn over time. And we see other people make the mistakes. You know, see the cases get litigated and then litigated again and again. But there's a very clear way to avoid these as much as possible. And that is to identify the soft spots and then do the diligence to make sure that you have the contingencies, that you have the deadlines, and then all of the other fabulous tips that you've given people, both for them. And I love that you empower the client here, because most people are like, well, the lawyer's there to draft it. The lawyer, they should just be able to rely on their lawyer. This, I always said to the client, this is your life. And the more agency you are able to take over it through every stage of this process, the better for you. And you're, you know, as you point out, it's not your lawyer who won't get the 50% of the pension or whatever the issue might be. It'll be you not getting something that you bargained for.
Double checking that your list pre-mediation is in the mediated agreement, because there is that opportunity for mutual mistakes to be corrected. You don't even need the other side to agree. If you can show a mutual mistake, that's something you and your lawyer can handle, because the other side really can't refute it. It's so important. And really, you have the ability, you know your facts better than anyone else, because it's your lived experience. It's really important to take that agency. You should do it for your financial future.
Oh, it's your financial future. I will say, with all the other topics we cover on the show, it's your emotional future too, because that
Absolutely.
empowerment to be on top of your future by understanding your agreement, knowing that your agreement, and think of everything this is not one of those episodes I think you listened to once. This is one of those episodes you listen to several times, because there's so much here to be aware of.
Well, we can
and to
highlight the
think
show
about.
notes.
Oh, we're absolutely going to highlight the show notes. And you have a wonderful resource for listeners to download. Do you want to tell them about that?
Yes. So we'll make sure that the show notes have the link for the worksheet on the enforcement suggestions, the conversations to have with your lawyer. So that link will be in there. And then another recommendation I have is to go to divorcethishouse.com. We have a directory of real estate agents and mortgage professionals trained in helping you avoid these enforcement problems with your house and your mortgage and other liens. So they've been trained in actually litigated cases. All of my classes are based on actually litigated cases. And they're really sincere professionals who want to make a positive difference in your experience.
Well, and that's a good point, because although a large part of my audience are the people going through divorce, I also have colleagues who listen to the show. I just talked to one today, and she said, as she's becoming a mediator, she listens more often, and it's one of her learning tools as she moves further into the profession. If colleagues would like to take one of these trainings that you're talking about or learn from you, is your website the best place for them to go?
Yes, so that website is vettingthehouse.com. Our continuing legal education is from vettingthehouse.com. Circle R, very proud of my Circle R.
Huh?
They're so backlogged, it took a year from the application for them to even look at it, but then we're registered. And I'm really proud of the continuing legal education we do, because these topics are so interesting. I've even taught judges in multiple states, and my judge review, she's so energetic about this topic. Yes, because we can prevent mistakes that can't be fixed. That's one of my core motivations, finding a mistake that could be prevented but can't be fixed. especially with things like the house and the retirement and all of those. It's a platform I'm proud to be part of.
I'm proud and delighted that you came on and we're here to share this with my listeners. It's a real eye opener. And I have to say, as a practitioner myself, it's an eye opener. We always, hear about these things, but to have it laid out with such clarity, I think is something that every divorce professional should take advantage of if you're representing clients, if you're drafting agreements, if you're negotiating things that aren't going to be finalized by the time of the divorce. It's probably a good idea to take this training. So Kelly, I want to thank you so much for taking the time to join me. You do have a lot of energy around enforcement, and I love that because there is really nothing worse than going through the difficult process of a divorce and a negotiation or trial, and then getting your judgment or agreement and then not receiving what you thought you were going to receive. It will have a lasting impact on so many ways on your future, on your beyond. So this is a truly important episode. Thank you so much for joining me.
Thank you, Susan.
As we wrap up today's episode, I want to pull together a few of the most important takeaways from this conversation. These are the insights I hope every listener carries with them, especially if you are in the early divorce process or heading toward mediation. Golden nugget number 1. I love the golden nuggets. A signed agreement does not mean you are protected. One of the biggest myths in divorce is believing that once an agreement is signed, everything is done. And God, we wish it was. But as we heard today, divorce agreements are not self-executing. If an agreement depends on future actions like refinancing a home, paying out equity, or dividing retirement assets, enforcement must be planned before you sign. Otherwise, what you thought you were getting may never materialize. Golden nugget number 2, deadlines and contingencies are not optional. Agreements without clear deadlines and consequences create what Kelly aptly described as the 12th of never, right? The date that never arrives. If there is no date by which something must happen, there may be no breach to enforce. And if there is no contingency spelling out what happens if it does not occur, courts can often be powerless to fix the problem later. Deadlines and contingencies are what turn promises into enforceable obligations. Golden nugget number 3. Homes and retirement assets are the highest risk areas. The most common and costly enforcement failures involve real estate and retirement accounts. These assets depend on lenders, plan administrators, and complex rules that are outside either spouse's control. Good intentions are not enough. These provisions require extra scrutiny, careful drafting, and backup plans if the original method of transfer fails. And golden nugget number 4, planning for enforcement is not distrust. It's protection. As Kelly emphasized, thinking through worst-case scenarios does not mean you expect them to happen. It means you are protecting your future. Asking what happens if a payment is missed, a refinance fails, or a retirement plan will not cooperate is not being difficult. It is being informed, proactive, and strategic. This was such an important conversation, and I'm so grateful to my guest, Kelly Lise Murray, for sharing her depth of knowledge and real-world experience with us today. Kelly's work focuses on what happens when divorce settlements fall apart after the ink dries, particularly in those cases involving homes, mortgages, and retirement assets. So if today's episode raised questions for you, that's a good thing. Kelly has created a free enforcement worksheet that walks through the key questions you should be asking your lawyer before signing any agreement. You'll find the link to that resource in the show notes and on the latest episode page at divorceandbeyondpod.com. I've also written a companion blog article for this episode called The Most Dangerous Words in Divorce. We'll handle that later. The blog article dives deeper into why enforcement issues are so often overlooked and how to think more strategically before you finalize anything. You'll also find the article linked alongside the episode as well in the show notes or on that latest episode page. As always, my goal here is to help you make informed decisions and avoid mistakes that can follow you long after your divorce is final. If you found this episode helpful, please consider sharing it with someone who may need to hear it. And thank you, as always, for listening to Divorce and Beyond, and I'll see you next time. If today's episode helped you see something more clearly, take a moment to reflect on one insight you can carry forward, one decision you can approach differently, one next step that feels more grounded. Divorce is not a failure. It is about facing reality and choosing a healthier path forward for yourself and your family. You can find show notes, trusted divorce resources, and expert guidance at divorceandbeyondpod.com. If this episode was helpful, follow the podcast and share it with someone who may need support right now. I'm Susan Guthrie. Thank you for listening, and I'll be back next time with more clarity, insight, and support on Divorce and Beyond.